Zachary Nicodem versus April Nicodem.
For the record, this matter is before the court this morning for pretrial conference. The same is being conducted via Zoom. Present is Attorney Eric Chappell representing the plaintiff, Zachary Nicodem. Mr. Nicodem is present. In addition, Attorney Maria Zagorski is present representing the defendant, April Nicodem, and Ms. Nicodem is present with Ms. Zagorski. Good morning, everyone.
Good morning, Your Honor.
The court notes reflect that the parties engaged in mediation with Mr. Godfrey on October 17th. Did that occur?
It did, Your Honor. Unfortunately, we were not able to resolve it. I think we got very close. We talked to Mr. Godfrey about maybe trying to see if he had a few more hours over the next several weeks to try to resume. Or, I'll let the court know I did make another offer after the mediation to Attorney Zagorski. Her and I were both in a full day trial though on Friday, Your Honor. So I don't think we were able to. Neither of us were attending to it after that. So.
Is there any merit in talking this morning? Would you like the assistance of the front of the court, Mr. Chappell?
Maria, I'd let Attorney Zagorski. I know that I'd sent that offer over. I'm not sure where we are on it. So.
I'm not sure that we'll be able to finish it with the front of the court this morning.
Okay.
All right. So you're waiting here for Mr. Godfrey. You're contemplating meeting with Mr. Godfrey for an additional mediation session. Is that correct?
Yes, Your Honor.
Okay. So what are the primary sticking points? Is there real estate that needs to be divided?
Value of real estate. Yeah. Value of real estate, Your Honor. And then what the marital interest would be in that. And then there's a retirement account that has to be divided as well. And then spousal support.
When spousal support presumably would be short-term rehabilitative spousal support. Looks like both parties are relatively young, a 12-year marriage.
Yes.
So the court would think it's a relatively short, unless there's a huge disparity in income, it would be just a very short spousal support term, if any.
There's a huge disparity in income, Judge.
Have appraisals been completed with respect to the real estate?
They have, Your Honor.
Okay. And if those appraisals are not sufficient, then perhaps the thing to do is simply liquidate the real estate. That's what the court would do at a trial. It's easier to divide cash than real estate.
Your Honor, the real estate's always been owned by Mr. Nicodem. It's a premarital asset. The issue is, what is the value of it what's the amount that has increased during the marriage?
Couldn't the appraiser help in that regard?
I believe it has, Your Honor.
Yeah.
We get a date of, we got a date of value, date of marriage value, as well as a value close to the date of the filing of the divorce.
That's correct.
So there's just one parcel of real estate. Is that correct?
That is correct, Your Honor.
Okay. Has discovery been?
There are, just so the court knows, because I know the court takes notes, there are issues with respect to the defendant's income. She's self-employed. We do think that her income is greater than what she has reported. But we've exchanged written discovery. Some material was produced in response to some of the requests that we submitted, but there will be some follow-up that I will have on it. In particular, we're looking for her calendar. She's a massage therapist. It's been her employment for a period of time. We asked for her calendar so we could see the amount of appointments. I got a handwritten calendar, and based upon conversations with my client, she keeps her calendar using her computer, like an iPhone calendar, etc. So I'll be looking for a production of that so we can actually see how much, how many appointments she has and what the comparative income would be as a result of it.
Judge, the parties have filed joint returns for the entirety of their marriage. So Mr. Nicodem is very much aware of what she makes. We do need a little bit more discovery, though, as to the value of personal property and other expenses made by Mr. Nicodem.
So personal property division is also an issue?
Yes.
Okay. The parties currently separated?
Yes.
They are.
The court would propose that we take the proofs this morning to establish jurisdiction. There's been a breakdown to stop the court's clock, so to speak, and then schedule another pretrial conference. Whatever date the two of you feel is necessary. Mr. Chaplain, Mr. Zagorski, is that agreeable?
It is, Your Honor.
Okay. Right. Mr. Nicodem, can you both please raise your right hand to be sworn, please?
48161.
All right. Prior to filing the complaint of divorce, had that been your legal residence for at least 180 days prior to the filing, including the immediate 10 days preceding its filing?
Yes, it has.
And in fact, that's been your legal residence for at least over how many years?
13, 14 years.
All right. You allege in your complaint that you were married to April Nicodem on November 2nd, 2012, in the city of Monroe. Is that true?
That's correct.
Okay. And is it also true that there's been no children born or adopted during the marriage?
That's correct.
Okay. You've also alleged that there's been a breakdown in your marriage relationship to the extent that the objects of matrimony have been destroyed, and that there remains no reasonable likelihood that the marriage can be preserved. Was that a true statement at the time you filed the complaint?
That's correct.
Is it a true statement today?
Yes, it is.
Have you in fact been living separate and apart from Miss Nicodem for a period of time?
Yes, I have.
How long has that been?
Since May the 5th,
Of 2024.
2024.
All right. So at this point, you do not see any possibility for reconciliation.
No, I do not.
Okay. To your knowledge, is Ms. Nicodem pregnant?
Not that I know of.
Okay. All right. Thank you, Your Honor.
Thank you, Mr. Chappell. Mr. Gorski, do you have any questions of Mr. Nicodem?
I do not.
Questions for Ms. Nicodem, please.
Thank you. April, would you state your name for the record?
Yep, April Marie Nicodem.
And you heard your husband's testimony this morning?
Yes,
Was everything he said true?
yes,
The marriage has broken down and there's no chance of reconciliation?
correct.
And you both have lived in Monroe County in the state of Michigan for 180 days prior to his filing?
Yes,
And would you please confirm that you are not pregnant?
not pregnant.
Thank you. That's all I have, Judge.
Thank you, Ms. Gorski. Mr. Chappell, any questions for Ms. Nicodem?
No, Your Honor. Thank you.
Based upon the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. Unfortunately, there appears to be no reasonable chance of reconciliation. At this point in time, the court will simply reserve all outstanding issues and schedule this matter for a continued pretrial conference. Mr. Chappell, Ms. Gorski, what time frame do you suggest to complete discovery? Obviously, Mr. Godfrey, unless he has a cancellation, he's probably booked until December.
He's into February, Judge, but
Yeah.
he did offer to slide us in somewhere. He said that he could probably get us in on a Friday afternoon.
Maybe mid-December, Your Honor. Just a suggestion.
Okay, you're not asking that the matter be set for trial at this point, is that correct? You want to still try to facilitate an amicable resolution?
Yes, Your Honor.
Okay. Is that agreeable then, Ms. Gorski, mid-December?
It is. Thank you, Judge.
Okay.
December 12th at, I have 11. December 13th at 11.
How about December 12th or the 13th at 11 a.m.?
Either one's
All
fine.
right.
with me.
Yeah. Well, I can have Attorney Waskoviak cover it, Your Honor. So if I could pick a day, it'd be the 13th.
Do you prefer the date that you're available, Mr. Chappell? Do you want the,
If possible, Your Honor. I've scheduled full day depositions in a case for the 12th and the 13th.
this court's always willing to accommodate parties and counsel.
Friday, December 20th.
How about December 20th, the following Friday?
It's open, Your Honor.
9 a.m.?
Yes.
Sure.
Ms. Gorski, does that work for you?
It does. Thank you, Judge.
Does it work for the parties? They'll be in town on December 20th?
It's a Friday.
Yes,
It'll
Does it
be a
work for you,
Zoom
Mr.
pre-trial. Very
Nicodem?
well.
Yes, if that's the soonest we can do it.
Well, we could do it in November, but the attorneys wanted in December. Everything is December 6th.
I'm happy to try November, Your Honor. I just, if there's going to be more discovery that Ms. Zagorski wants, I don't want to appear and then waste the court's time or the party's time.
Agreed.
Okay.
Yep.
Yeah, December 6th, the court is a trial at that time, so we will schedule it for December 20th at 9 a.m. via Zoom. Cole, mail out notice.
Thank you.
Right, Mr. and Mrs. Nicodem, without question, the best resolution is one in which you both participate. You both represented by very capable family law practitioners. Hopefully you can come to your own resolution. That's clearly the best. Right, with that, we're going to zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you, Judge.
Welcome. For the record, this matter is before the court for a pretrial conference. Subsequent to the parties having engaged in mediation with Mr. Walker from the front of the court this morning. This hearing is being conducted via Zoom. Present is attorney. So we had Mr. Baker here before for Mr. Vandergrift.
Yeah, I'm sorry, Your Honor. Mr. Baker had to step out for another hearing. This is Attorney Brian Walker appearing on behalf.
Good morning, Mr. Walker. So Attorney Brian Walker is appearing on behalf of the plaintiff, Virginia Vandergrift. Ms. Vandergrift appears to be present. In addition, Attorney Daniel Lipsitz is present representing the defendant, Shane Vandergrift, and Mr. Vandergrift is also present. Good morning.
Good morning.
Morning.
It was a relatively quick mediation this morning. Mr. Walker, are the parties asked for a trial date, or do we have a resolution?
Your Honor, we have a consent judgment that's been signed by both parties.
Wonderful. So someone will be mailing that in?
Yes, Your Honor.
Okay, so we'll take the proofs this morning and put that agreement upon the record. Is that correct?
Yes, Your Honor.
Wonderful. Mrs. Vandergrift, can you both please raise your right hand to be sworn, please?
Yes.
Solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
I do.
Thank you. All right, to Mr. Walker, if you're going to begin with Ms. Vandergrift, please.
Ms. Vandergrift, please state your name for the record.
Did you say Mrs. Vandergrift?
Yes.
Virginia Lee Vandergrift.
Okay, at the time of the filing of the complaint for divorce, did you live in the state of Michigan for 180 days in the county of Monroe for 10 days?
Yes.
At the time of the filing of the complaint, were all of the allegations in the complaint true, and are they still true today?
Yes. Yes.
Is it true that there's been a breakdown in the marital relationship, that the objects of matrimony have been destroyed and there remains no likelihood of reconciliation?
Yes.
If this judge refused to grant the judgment of divorce, would you be able to live as husband and wife?
No.
Okay, are you currently pregnant?
No.
Okay, have you read the judgment that you signed on October the 20th?
Yes, I have.
And do you agree with it and understand the terms in it?
Yes, I do.
Do you understand that by entering this judgment, you're waiving your right to a trial, and if you went to trial, you could receive more or less than the property you're receiving today?
Yes.
Do you believe that the judgment reflects an equitable division of your property and assets, and all the assets have been disclosed?
Yes, I do.
That's all I have, Your Honor.
Thank you. Thank you, Mr. Walker. And I apologize if I missed the answer to this question. Ms. Vandergrift, were there any children born or adopted during your marriage who are still minors?
There's one minor.
Thank you. Mr. Lipsitz, do you have any questions for Ms. Vandergrift?
Not for Ms. Vandergrift.
Okay, questions for Mr. Vandergrift, please.
Thank you. Mr. Vandergrift, you have also signed a consent judgment in this case. Is that correct?
Yes, I have.
You reviewed that. Is that correct?
Yes.
All right. That provides for a division of your assets and debts. Is that correct?
Yes, sir.
You believe that is fair and equitable?
Yes, I do.
Okay. It also provides for a custody arrangement and for joint legal and joint physical custody. Do you believe that's in your child's best interest?
Yes.
Okay. And do you understand that you could have gone to trial in this case and you could have gotten the same thing, better or worse? Is that a fair statement?
Yes.
All right. And it also provides a term of spousal support that you're going to pay Ms. Vandergrift. You understand that that's a non-modifiable term of spousal support?
Yes, I understand.
Okay. That means you can't come and ask that it be changed, and Ms. Vandergrift can't come ask that it be changed.
Very good.
Okay. And you understand that after that term is paid, that spousal support is forever barred for both parties. Is that accurate?
Yes, sir.
Okay. And that child support is reserved and neither party is paying child support right now. Is that accurate?
That's correct.
Okay. I have no further questions, Your Honor.
Thank you, Mr. Lipsitz. Mr. Walker, do you have any questions for Mr. Vandergrift?
No, Your Honor, I do not.
Very well. The court would like to acknowledge Mr. Baker, Mr. Walker, Mr. Lipsitz for helping facilitate amicable resolution between the parties. And the court would applaud you, Mr. and Mrs. Vandergrift, for reaching your own agreement. They're both represented by capable family law practitioners, and the court can assure you without question the best resolution of matters of this nature is one which you both participate and agree upon. far better off than throwing things up in there and have the court decide these matters. So I applaud you for reaching your own agreement. It's wonderful you can co-parent your child. With respect to the statutory 6-month waiting period, Mr. Walker, Mr. Lipsitz, the court notes that it expires in November. Actually, it's right around the corner. How long have the parties been separated?
The parties have been separated for, it was quite a while. I don't know the exact date. Mr. Graham, do you know the exact date, Mr. Vandergrift?
January.
Your Honor, and
20.
part of the settlement is that Mr. Vandergrift does need to refinance the house and pay off Ms. Vandergrift. So there is some urgency in getting the judgment signed as well.
Very well. For those reasons, the court will in fact waive the balance of statutory waiting period. And there the judgment of divorce upon presentment. Again, thank you, Mr. Walker, Mr. Lipsitz, for your assistance. Based, however, on the testimony that's been presented this morning, as well as complaint filed this case, court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved. The judgment shall enter granting a divorce for the bonds of matrimony. Good luck to both of you. That will conclude this hearing. Everyone can zoom out and have a good rest of the day.
Thank you.
Thank you.
Thank you, Your Honor.
Welcome.
Calling the matter of Dylan Wagy versus Jordan Mann.
For the record, this matter is before the court for review. Subsequent to the parties having engaged in mediation this morning with Mr. Walker from the front, with Ms. Brower from the front of the court. Present is Attorney James Petrangelo representing the plaintiff father, Dylan Wagy, and Mr. Wagy is present. And it appears also that defendant mother Jordan Mann is also present. Good morning, everyone.
Morning.
The primary issue was just simply reviewing parenting time. Is that correct, Mr. Petrangelo?
Yes, Your Honor. We wanted to make sure we were clear on support and health care and all of those issues to go into a final judgment. The parties have met with front of the court and agreed to a total resolution here, which I would announce with the court's permission.
Please.
The parties have agreed to follow the temporary order that was issued in this court on September 18th. That called for joint custody, with mother having Mondays and Tuesdays overnight, father Wednesdays and Thursdays overnight, rotating a 3-night weekend of Friday to Monday, mother picking up Mondays at 10, father picking up Wednesdays at 4:15. On mother's weekend, she was picking up 10 a.m. on Friday. The parties have a written holiday schedule they're going to provide to me to attach to the order. It differs somewhat from the front of the court standard order, but I've been advised that they both agree to those terms. As far as financial matters, they've agreed that they will alternate claiming the child as a tax exemption, with father having odd-numbered tax years and mother even-numbered tax years. Child support would be reserved, and I would indicate that Ms. Brower ran calculations, and they were very minimal if ordered, because father pays a health insurance premium of $222 a month to cover the child. So we would reserve child support. He would continue to maintain health insurance for the child. Under this circumstance, they've agreed to split any uninsured medical costs 50-50. And those provisions would go into effect immediately. I would prepare an order, send it to Ms. Mann first I'll try to send it and have them each sign and send it back to me. And barring that, I've told her she would receive a notice with 7 days to object if she didn't respond. But sounds like we'll be able to get this all settled.
And you'll prepare an order incorporating all this, Mr. Petrangelo, is that correct?
That is correct, Your Honor.
Wonderful, thank you. Right, Ms. Mann, did Mr. Petrangelo accurately state your agreement?
Yes, sir.
Right, Ms. Mann and Mr. Wagy, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony about the given matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Wagy?
Yes, sir.
There, you got to speak up a little bit so we can capture responses to the questions put to you. Thank you. Mr. Petrangelo, you can just briefly order your client to confirm his understanding of this agreement, please.
Yes, Mr. Wagy, did you hear the agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Are you asking the court to adopt this?
Yes, sir.
Do you understand you didn't have to agree to this? We could have asked for a hearing and the judge might have come up with something totally different.
Yes, sir.
Knowing that, are you waiving any request for hearing and asking him to adopt this as a final order?
Yes, sir.
Do you believe this is in the best interest of your child?
Yes, I do.
No further questions of my client, Your Honor.
Thank you. Ms. Mann, could you please state your name for the record, please?
Jordan Mann.
Ms. Mann, do you believe the agreement stated by Mr. Petrangelo you reached with Mr. Wagy to be in the best interest of your child?
Yes, I do.
Do you have any questions for Mr. Petrangelo?
I do not.
Do you have any questions for the court?
No.
Mr. Petrangelo, do you have any questions of Ms. Mann?
Just Ms. Mann, you understand I represent Dylan in this matter, and although this has been cooperative, I haven't indicated I'm representing you in any way. Is that correct?
Yes, sir.
And you're ready to proceed with this knowing that?
Yes, I am.
All right. Nothing further, Your Honor.
Well, the court would like to thank and acknowledge Ms. Brower for her assistance in helping to facilitate the resolution this morning. And the court would applaud you, Mom and Dad, for reaching your own agreement. It's wonderful. You know what's best for your child. Always remember that, better than anyone in this world, including the court. So it's wonderful you're able to co-parent and reach your own agreement. And there will be challenges in the future. As River gets older, there'll be more activities, but it's all about effective communication. So communicate with each other in the best interest for your child, and your child will thrive. The court finds agreement between the best interest of minor child. The court will accordingly adopt the agreement and enter the order upon presentment. So that will conclude this matter. Everyone can zoom out and have a good rest of the day.
Thank you, Your Honor. Just so they know, I'm going to send out an order and I'm going to ask them to sign the same document. So I'm going to ask them to circulate it between them and get it back to me as quickly as possible.
And they will also provide you with a copy of their holiday parenting schedule. Is that correct?
That's right. Mr. Wagy has indicated he'll get that in today or tomorrow, so I can attach that.
All right. Thank you.
Thank you, Your Honor.
All right. Everyone can zoom out. Have a good rest of the day. Thank you, Ms. Brower.
You're welcome.
Mr. Martin, did you stop down in front of the court to make a payment? Okay, I'm just telling you. Okay, well, the attorney's been trying to call you. Mr. Martin just showed up. He's about 10 minutes late. Okay, Mr. Leiter, we're going to, do you want, I guess we can have Mr. Martin go down in front of the court and make a payment and talk with you?
That
Mr.
would be
Martin,
great, Your Honor. I did try. I made exactly 3 calls this morning. I got the answering machine, all 3.
Can I see the file, please? We'll call it for case. Yep. Okay, we're having problems with the recording system, but look at the phone number that the court provided. It's 419-654-2393. Is that correct? All right. So maybe the court miswrote his number. Okay. Do you want Mr. We can have Mr. Martin step out and call you.
Your Honor,
Mr.
I'll
Leiter,
give
do you
him a
want to-
call. That's no problem whatsoever.
All right. So Mr. Martin, why don't you step out and you can talk, his conference room is across the hallway, talk with Mr. Leiter. For just everyone's information, it's a private show cause matter. I think the court suggested Mr. Martin pay $1,000 today toward the rearages. Is that correct? Yes, sir. So why don't you go down and make that payment and talk with Mr. Leiter? The rearages are pretty significant, if the court recalls.
She's not going to school. So support should be stopped. Well,
but this is Mr. Leiter is representing you on contempt only. He can't. Maybe he can give you some direction, but you should talk to the front of the court caseworker. So go down and make that. Go on to talk to Mr. Leiter. After you do that, go down and make the $1,000 payment. Mr. Martin, you might have borrowed gas money from someone else. Yeah, he's going to probably step out there, go down in front of the court and make that $1,000 payment. Come back up and talk to the front of the court caseworker. Because they can give you a form motion. You might not need to file a motion to discontinue support. Right. He stepped out, Mr. Leiter. He's going to call you, and I think he's going to come down and make $1,000 payment. Ms. Six.
Thank you.
This is they stated it's a private show cause. I'm surprised Mrs. Sorter's not here because she's the one who initiated this.
Your Honor,
Thank you, Your Honor.
it is the position of the friend of the court that this is not our show cause, as you stated, so we would not be pursuing or proceeding in any way without her present. It is her, it's similar to her filing a motion. If she doesn't appear for it,
Understand, we've already got a court-appointed attorney in place. I'm inclined to proceed. But obviously he's appeared today, so maybe we don't need your assistance in terms of a bench warrant since he has appeared.
absolutely. I'm going to wait and hang out and see, and I'll make sure that he comes down and makes that payment so I can confirm it for you guys.
That'd be appreciated. And if so, the court would be inclined to find him in contempt, would reserve any sentencing, Mr. Leiter.
I think he's on the phone with him now.
All right.
I'm sorry, Your Honor. Go right ahead one more time.
Well, if in fact he makes that payment $1,000 today, the court's inclined to simply find him in contempt, but reserve sentencing, and sort of give him the key to the jail, and we'll put the matter back on Ms. Six docket.
Your Honor, I can't do that. The friend of the court would have to start our own show cause up. Our chain is closed because a private show cause was canceled. It can't just be placed back on my docket. We have to start the process.
Go out there and I'm going to shut it down and start it back up.
So what does it take to get it back?
Well,
on
yeah,
your
I'll have
docket?
to reopen the meeting and do all that again.
Hold on,
I just
sir.
have Rebecca
talk with IT.
Dim Lighter here, but
Hey, Sarah, we can hear you out here.
I know you should.
The rears are, I think, next has a $5,000. I don't want to keep this on my docket forever.
Correct, Your Honor. The friend of the court has processes that we can follow once you are done with her private show cause, but we cannot do a show cause while there's a pending private show cause. So if
I understand
make
that.
a final order in yours today, then it doesn't get just adjourned to our docket. We would have to start a new motion in order to show cause, which we can do.
Couldn't we put it simply on your docket for review?
No, because there's not an open docket with an open chain. That's not my chain has been closed.
Hold on, I'm not sure you may open chain, but we have an open case here. There's
Your Honor, I'd rather not keep discussing this while it's live streaming on YouTube.
Oh, okay, I didn't realize that. Okay, I thought Sarah couldn't do that. Talk with Patrice. I'm just trying to figure out how to handle this and try to keep Mr. Martin in line.
Absolutely.
Just trying to avoid her having to file another motion in 2 months from now. Okay, I didn't realize we're streaming. I thought she couldn't get us online. All right. Hopefully, Mr. Martin, you can confirm he made that payment. We'll go from there.
Yep, I'm going to go out and check that he's doing that now. Thank you, and I'll be right back.
All right, thank you.
So, Judge, I have to shut down the computer and start it up again because IT can't get it to come up either.
I didn't realize we were streaming to YouTube.
Oh, because I came out.
Shut us down, please.
IT. Hold on. I gotta go out there.
Yeah, I didn't realize we were still on YouTube.
Disorder versus Devin Martin.
For the record, this matter is before the court for contempt proceedings. Mr. Martin has personally appeared this morning as ordered by this court. Also, his court-appointed attorney, Mr. Timothy Leiter, is present on Zoom, as is Monroe County Front of the Court Attorney Rebecca Hicks. Good morning, Mr. Leiter and Ms. Hicks.
Your Honor, good morning.
Morning.
Ms. Hicks, the court recognizes this, of course, as a private show cause. We are able to verify that Mr. Martin made a payment this morning of $1,000.
Yes, Your Honor, he did.
And with that payment, how much are the remaining arrears according to the front of the court records?
In total, $5,171.94.
And that was after the $1,000 payment?
That is correct, Your Honor.
Okay. Can you just, when was the last payment made prior to today?
July, Your Honor.
Thank you, Ms. Hicks. Mr. Leiter, have you had a chance finally to discuss the matter with Mr. Martin this morning?
I've had a chance to discuss this matter with Mr. Martin. And unfortunately, Your Honor, I think Mr. Martin is kind of more focused on, oh shucks, issues with his, I guess, his soon-to-be 18-year-old daughter, as opposed to the contempt. I did advise him that if he pled to contempt, I do believe, and if I'm speaking out of, if I'm not speaking correctly, Your Honor, please correct me, that there's an inclination to not impose any jail time, but just to set the matter for a review down the road with Ms. Hicks.
That's correct. Again, right now, I'm not sure how soon it will come up on Ms. Hicks' docket, but yes, any finding of contempt, the court would reserve sentencing. So the court would hand Mr. Martin the key to the jail, and he would not serve a day in jail unless he just ignored the request of the court. And Ms. Hicks, Mr. Martin has raised an issue. He needs to talk with his caseworker about getting a form to file a motion to abate support or terminate support, correct? If a child is in the age of 18 and not going to school. And
I did speak with him at the window, Your Honor. I provided him with the motion packet as well as the document we had received from the child's school to indicate what her graduation date is, so he knows who to contact at the school about verifying and confirming whether she is in attendance or not.
Okay, so you'll need something writing from the school that she's no longer in attendance?
Or for him to file the motion with it, correct, Your Honor.
Okay, but he will have to file a motion, either referencing the date she vacated school, but hopefully have something in writing from the school. Is that correct?
That is correct, Your Honor.
Okay, thank you, Ms. Hicks. Right, Mr. Martin, do you understand? First of all, are you satisfied you've received the right to legal counsel by conferring with Mr. Leiter? Of course, he's representing you on this contempt only. Okay, if you, it's the court's opinion and intent that if you admit to contempt, you got arrearages in excess of $5,000. After this payment, the court would impose a sentence 45 days, but suspend that. And you would hold the key to jail. You would not serve a day in jail unless you put yourself in there. You understand that?
Yes, sir.
Okay. Do you want to talk with Mr. Leiter any further? I mean, you do not be going anywhere today. You go home today, back to work. Is it, are you satisfied again that you've received right to legal counsel?
Yes, sir.
Okay. And you've got the form that's something you have to do on your own in terms of filing a motion to abate support, and definitely do that. Fill out the paperwork. Get that filed as soon as possible. Contact the school. So, Mr. Martin, is your intent to admit to contempt this morning?
Yes, sir.
All right. Please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Please state your name for the record.
Devin Martin.
Mr. Martin, do you admit and acknowledge that you're obligated to pursue the order of this court to pay support for the maintenance of children born to you in a mandamus order?
Yes, sir.
Do you admit and acknowledge that prior to your $1,000 payment today, you had, after your payment today of $1,000, you have still have arrears about $5,000? Do you admit and acknowledge you have not made any payments since July of 2024?
Yes, sir.
Have you had any income during the months of August and September and October?
A few weeks ago, I had.
So you had no income at all during the months of August and September?
No, I mean, we're in the
How did-
process of moving, like I'm getting paid to them, I owe. I'd like to admit it as a man.
What efforts did you make to secure employment during the months of July and August? I mean, August, September.
I've been on.
Did you apply for unemployment?
I don't get.
Well, you're unemployed.
Not on the books.
What do you mean? So you're paid cash on your prior job?
My brother, yeah.
All right.
Like self-employed.
So how did you buy groceries and pay your utilities during the months of August, September?
I have some.
Okay. Do you have any disability that prevented you from securing some type of employment, whether it's landscaping or otherwise, during the months of August and September? Okay. Mr. Leiter, do you have any questions, Mr. Martin?
Do not, Your Honor.
All right. The court finds in this case that a support order exists in this matter. The arrears prior to today exceeded $6,000. They've now been reduced to $5,000 by virtue of Mr. Martin's $1,000 payment. The fact that Mr. Martin did not make any payments during the months of August and September 2024. He has no disability, nothing that prevented him from making a payment or filing a motion to reduce the support. The lack of due diligence on the part of Mr. Martin is a basis in this court's opinion for a finding of contempt. According to this court, will find Mr. Martin to be in contempt of court. And the court does intend to impose a suspended sentence. Mr. Leiter, anything you want to say before the court imposes a sentence?
Oh, nothing further, Your Honor, other than we do thank the court, and I do thank Ms. Hicks for her help with this matter.
Mr. Martin, anything you want to say before the court imposes a sentence? Okay, so you have to, the court wants you to be proactive, so definitely file that motion. And again, that will apply to any future support, but you can't go retroactive. So you still got to deal with this 5,000 arrears. So at this point in time, the court's simply going to order these for 45 days jail, but suspend that jail. Okay, and Ms. Hicks would let the matter take its own course, and correct. So after some period of time, if there's a couple months of no payments, then your office will start a show cause, or you'll send out a notice for Mr. Martin to appear. All right. Okay. I think that will be sufficient. The court would note that Ms. Orr did not appear this morning. She was here on October 8th. So we will not schedule a future review at this time. We'll just simply let the matter take its own course. All right. Thank you, Mr. Leiter. Thank you, Ms. Hicks.
Thank you, Your Honor.
Thank you, Your Honor.
There's no future court dates. Obviously, if in fact there's no payments in the future, the front of the court will send you notice to appear. And just make sure you appear, be proactive. That's all you need to do. And file that motion as soon as possible, because that will perhaps stop any future support. And whenever she left school, if you were aware of that, that's when you should have taken action.
Done with all her work for senior year.
Yeah.
You know, like.
Well, you get documentation she's going to graduate, because that will assist. At least talk with the schools. At least you talk with the schools to get some verification that she will in fact graduate.
Yeah, I am.
Okay. All right. All right. Thank you, Ms. Hicks, for checking in at the last moment. Appreciate it. This hearing is being conducted via Zoom. Present is Attorney Kimberly Kuhn, representing the plaintiff, Mary Hams. Ms. Hams is present with Ms. Kuhn. Good morning, or good afternoon, I should say. In addition, Attorney Laura Walesh is present representing the defendant, Michael Dukwitz. If I pronounce that correctly?
That's close enough.
Mr. Godfrey, have the parties, with your assistance, been able to reach their own agreement?
Yes, they have, Judge, and with the court's permission, I'll place that on the record.
Wonderful. Please, Mr. Godfrey.
We have one parcel of real estate. It is located at 2 acres, is awarded to wife. Husband shall execute an appropriate quitclaim deed to transfer his interest in this property to wife. Wife's attorney would be preparing that deed. That deed should be signed now, but that would be held by husband's attorney until the refinancing or sale of the property, whichever occurs, until the refinancing to get husband's name off of the underlying mortgage. Wife has until May 1st of 2025 in which to accomplish that, to get husband's name off of that mortgage. Court would retain jurisdiction over the property to fashion any remedy the court deems appropriate. And that can include failure to make timely payments on the mortgage, Husband will make the mortgage payment as he has in the past until the first day of the first month after he vacates the residence. Husband shall vacate the residence on or before December 31st of 2024. Assuming he vacates in December, wife would then be responsible for the mortgage payment starting January 1 of 2025. But in any event, she has to start paying the first day of the first month after husband vacates. All utility bills on the property, husband would continue to pay until he vacates the property. He would then pay through the time he was there. There might be some proration on a tax bill, but whatever time he was there, he pays through, and then wife is responsible for it after he vacates. If there is any escrow balance, that is awarded to wife. The interest for husband in this property is $56,900, and I will discuss how that is allocated shortly. The insurance and taxes, there is escrow for that, so that is staying with the wife. Any questions dealing with the real estate? I hear none. I'll keep on going. Automobiles, wife is keeping the following items. The 2004 Dodge truck, I treated as premarital. The 1992 Mercedes wagon, and there is a title to that, and it says it's a 1992. So the 1992 Mercedes wagon. There is an automobile, a 2018 Audi Q5. That is going to be awarded to wife. There was a value allocated to that, and as part of the overall settlement, I took that into account. So those three items are awarded to wife. There's a 2000 Mercedes SL 500. That will be sold forthwith by the parties. The net proceeds divided 50-50 between them. The insurances on these items, the insurance would be paid for by husband through November of 2024. So after November of 2024, wife would be responsible for the insurance on the vehicles that she is keeping. Hopefully the 2000 Mercedes SL 500 is sold by the end of November. Should be no reason that cannot be sold forthwith. Just for reference sake, it was valued at $79.25 by a recent valuation on that, but they can sell it for whatever they deem appropriate. Bank accounts, there are no joint bank accounts. Wife is awarded her bank accounts. Husband is awarded his. Wife had a Fifth Third checking. Husband had a Fifth Third checking and a Fifth Third savings. Each keep their own, and that basically offsets the value of the vehicle that is being awarded to wife. There is a joint, there's a securities bank account at Fifth Third Bank, ending, I believe, in 2453. That securities account, the first $145,100 is awarded to husband. Any amount over that $145,100 would be split 50-50 between the parties. That $145,100 is based on the husband having a premarital $88,200, which was the sale of his condo, plus the $56,900 for the interest in the marital home. The parties are available today, and I would hope that they could go to Fifth Third Bank today to get that split so that there would be money available for wife if she wants to cash some in to get cash. There's a safety deposit box at Fifth Third Bank. The parties should go to Fifth Third Bank jointly to empty the contents. In that safety deposit box, there are coins, and I put coins, but there could be precious metals, gold, silver. But whatever is in there from the coins, precious metal, would be taken to Toledo Coin Exchange to be sold. The net proceeds from the sale of those coins would be divided 50-50 between the parties. If there is any tax consequence resulting from that, each of them has to report half of the tax consequence on their own tax return. There are paintings that the parties have. I don't know the total number, Judge, 80 plus potentially. I have all of these certificates of authenticity. Those would be all sold. They're going to be sold using the Karen Rose auction house, and it would be sold subject to her contract, which is basically she would do an online only auction. There is no reserves. The platform that would be utilized offers the paintings to the entire world to bid on. She is off the top. She gets a 28% commission. That would cover any credit card back charge, the 3% or whatever the auction company is back charged. There is an additional $850 for what I refer to as setup cost, which she will take the inventory, the pictures, descriptions, and put those all out there to be bid on. There is another fee that the proxy bid company takes, which she will cover of $500. There is also a 15% buyer premium, which goes to the proxy company. But at the end of the day, whatever the net is, they're going to split 50-50. There's no reserves on those photos or those pictures. If either one wants to bid on those, they can certainly bid on them if they want to buy them. Any net proceeds divided 50-50. If there's any tax consequence, they report that on their return 50-50 as well. Speaking of the tax return, the parties would file a 2020 state and federal income tax return. The judgment of divorce would enter right after the first of the year. As to the 2024 taxes, if there's any net refund, that would be split 50-50 by the parties. If there's any liability, husband would be paying that. Now, if wife liquidates some holdings that are being awarded to her out of the Fifth Third securities, she has to take and withhold state and federal tax on that. She just can't take all of the money and then expect husband to pay the tax on that. So I think historically, the Fifth Third Bank has been withholding 25% to cover state and federal taxes on the accounts that have been liquidated. If husband takes any RM, I'll talk about retirements. Retirements would be allocated as follows. I got to get back to my page. All right. There is an East Penn 401k that is all marital. That is split 50-50 with a valuation date of September 30th of 2024. If there is a need for a quadro for that, it would be prepared by Ann Pastrana. The cost of that would be shared 50-50 by the parties. If there's any cost by the plan administrator to implement that, that cost would be shared equally as well. There is also an IRA at Fifth Third Bank ending in 1477. Hopefully the parties can simply do a letter of instruction to have that split 50-50. And there is no valuation date on that, Judge, because there's no additional contributions being made to that. So whenever it is split 50-50. There is another IRA at Fifth Third Bank. Wife is awarded 7.41% of that IRA at Fifth Third Bank, and that ends in 00194. Husband may take out of that his required minimum distributions. If he takes that out before it has been split, wife is entitled to 7.41% of the net of any funds that were taken out. Net would be after the withholding of the taxes. There is an Exide retirement pension that is is awarded to husband. I treated that as premarital. Any questions to this point by the parties?
Quick question, Bill. If the coins and the artwork get sold prior to the end of the year, the parties are going to have to put it on the joint return. So how are they going to?
Any tax allocated to that would be shared 50-50 by the parties.
Okay. And then anything after?
Anything after January 1 of 2025, each picks up whatever they have to.
Okay. And then with the other IRAs, other than the RMD coming out of the account number Fifth Third Securities account 0194, there would be no withdrawals from any of those other security
accounts. That is understood. Correct, Michael? You would only take the RMD out of that one account.
Yeah, until they're divided. That's all. Just whatever is required.
Yeah. Okay.
And I'm assuming that there's no loans on the East Penn 401k?
No loans. Never took a loan out except on a house and a car.
Perfect. Thanks.
All right. So personal property. Husband is awarded the dog Stella. Wife is awarded the 3 donkeys and the chickens. After that, they would split everything else on their own. If they cannot reach an agreement on the division of the personal property, it would go to binding arbitration. The parties need to request the binding arbitration by February 1st of 2025. Absent a contrary agreement of the parties, I would act as the binding arbitrator. The cost of the arbitration would be split 50-50 by the parties, and no attorneys would need to be present. The parties have been advised that the sole role of the court would be to enforce the award of the arbitrator, that the court would not be involved in any division of the personal property. If they did not like how it was divided by the arbitrator, it does not matter. The court's sole role is to take the arbitration award and enforce it. I've instructed the parties that if, as the part of the binding arbitration, I have 3 rules that I follow. Rule number 1, if a party brought an item into the marriage, it stays with the party that brought it in. Absent some compelling reason where they put money into it, it just stays with the party that had brought it into the marriage. Rule number 2, if there was an inheritance, it stays with the side of the family that it came from. Rule number 3, if there was a gift given to someone, it stays with the recipient, and we don't value that. So if there was baubles given to the wife, she keeps the baubles. If a drill was given to the husband, he keeps the drill, and I do not get into the valuations of those. Other than that, everything is free to be divided, and the parties understand that. Any questions by the parties dealing with the arbitration process?
All the personal property in the house that isn't inherited or a gift or you brought in, everything is up for grabs.
Other than the dog and the 3 donkeys and the chickens.
Anything that you purchased during the marriage, any property in the home that was purchased during the marriage, if the 2 of you cannot divide it, you will have to get a hold of Mr. Godfroy and you're going to arbitrate it. You'll spend a lot more money in arbitration than you will trying to figure out how to divide it.
I would gladly divide it if they want to pay me. All right. Any more questions on the personal property?
No, sir. Thank you for those ground rules, Mr. Godfroy. I think that will be helpful to the parties.
Life insurance, each party would keep their own. They're free to name whomever they desire as a beneficiary on their own policy. There is no joint marital debt other than the mortgage, which I've already talked about. I've already talked about the 2024 taxes. Wife never took husband's surname, so I don't have to worry about the maiden name restoration. Health insurance, each party is covered by Medicare, and each party would be responsible for their own health insurance coverage post-divorce at their own expense. If either party had incurred any medical procedure that was not covered by insurance, each party would be responsible for their own uninsured medical expense. Attorney fees, each pay their own. Spousal support is forever barred. Neither party may ever come into court requesting spousal support. Car insurance, if I have not previously indicated, husband will pay the November car insurance bill. Thereafter, each party is responsible for their own car insurance. There are no streaming services. Utilities are currently coming out of husband's credit card. Those should be transferred to wife's credit card after husband moves out. And again, he would be responsible for all utility bills until he moved out. Phone, the November bill, or the phone is wife's phone plan. Wife needs to get that transferred and put on her own credit card, but husband would make that payment for November of 2024. Wife would be responsible for her payment starting December of 2024. That is the agreement, Judge.
Thank you, Mr. Godfrey. Ms. Kuhn, did Mr. Godfrey accurately state your client's agreement?
He did.
All right, thank you. Ms. Lush, did Mr. Godfrey accurately state your client's agreement?
Yes, he did.
All right, so Ms. Hams and Mr. Dukwitz, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. Ms. Kuhn, the court would know we did take the proofs back on July 22nd, so if you could simply confirm with Ms. Hames that she is not now pregnant, and then you confirm with her understanding of the agreement, please.
Thank you, Your Honor. I will do that. Mary, can you state your full name for the record?
Mary Patricia Hames.
Mary, you testified in July that you were not pregnant. Is that still the case?
Yes.
And Mary, you heard the agreement that was read on the record, correct?
Yes.
You understand that the agreement takes into considerations claims regarding spousal support, claims regarding equity interest in the marital home. And with all of those claims and consideration and moving parts, you understand the agreement in its entirety, correct?
Yes, I do.
And you understand that had we gone to a trial in this matter, the result could have been better, it could have been worse, it could have been the same. You understand that, correct?
Yes.
Notwithstanding that fact, are you asking that you not have a final hearing in this matter and that the court adopt this agreement in its entirety and make it a binding order?
Yes, I do.
And is it fair that you and I had an opportunity to meet prior to mediation to discuss all of the issues that were addressed at mediation today?
Yes, we did.
And did I answer all of your questions?
Yes, you did.
And did I answer your questions today?
Yes.
Do you have any questions in regard to any of the issues that are that make up this agreement?
No, Kim.
Okay, you don't have any questions of the mediator?
No.
Or of the court?
No.
And are you knowingly and are you entering into this agreement voluntarily?
Yes.
And nobody made any deals with you to enter into this agreement?
No.
There's no side deals, correct?
No.
And with regard to spousal support, you understand that spousal support is barred. That means that a month from now, a year from now, 5 years from now, you cannot petition for spousal support.
Okay.
Your husband also cannot petition for spousal support.
Okay.
That means that that issue is forever off the table. You understand that, correct?
Yes.
And you also understand that there are certain obligations that are financial that are going to be required of you when December 31st, when your husband moves out in December, or if he were to move out in November, there could be the possibility of that occurring and you would be responsible for that mortgage payment.
Yes.
Okay. And you understand that that payment needs to be timely made. And if it's not, your husband could petition the court to either find you in contempt or to sell that house sooner than what time period you've been given under this agreement.
I understand.
Okay. And with regard to the artwork, you understand that both you and your husband are going to have to contact Karen Rose. You're going to have to make all of the arrangements to get the artwork to her, but that's something that both of you are going to have to do. You understand that, correct?
Yes, I do.
And with regard to the coins and any precious metals, same. You're both going to have to work together and do that, correct?
Yes.
Okay. Are you satisfied with my advice and counsel?
Yes.
Okay. I don't have any questions. Thank you.
Thank you, Ms. Kuhn. Ms. Walesh, do you have any questions for Ms. Hames?
I do not.
Okay, questions for Mr. Dukwitz, please?
Yes. Did you hear and understand the complete agreement that our mediator read into the record?
Very clear. It's very good.
Okay. Do you have any questions for me or for the court?
No, I don't.
Do you believe that it was a fair and reasonable settlement?
Yes.
You understand that you're not going to be divorced until after the first of the year.
Correct.
But that this property settlement, now that it's on the record, is final and binding and cannot be changed in any way.
Yes.
And you wish to be bound by it?
Yes.
Did anyone force or coerce you to enter into this agreement?
No.
You're entering into it voluntarily?
Yes.
Do you have any, you said you don't have any more questions for me or for the court?
No.
Have you been satisfied with my services?
Very satisfied.
All right. I have nothing further, Your Honor.
Thank you, Ms. Walesh. Ms. Kuhn, do you have any questions of the defendant?
Yes, did you make a full disclosure of all of your assets and all of your debt?
Yes, I did.
Okay, no further questions, thank you.
And you'll prepare the judgment, Ms. Kuhn?
I will,
And again, that was be submitted in January because the party's going to file a joint tax return. Is that correct?
correct.
Yes, Judge.
We'll note that in our records then. Obviously, the sooner that's prepared and circulated, then the better. Ms. Kuhn, so there's no issues. Court would like to acknowledge Mr. Godfrey for his fine assistance in helping these parties reach their own agreement, as well as, of course, the attorneys Kuhn and Walesh. Based upon the testimony that was presented this afternoon, as well as previously, as well as point filed in this matter, the court once again finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship. There's no chance of reconciliation. Accordingly, upon receipt of the proposed consent judgment, the court will sign that judgment in January of 2025, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce and bonds matrimony. That will conclude this matter. Thank you, Mr. Godfrey, for your fine assistance. And so everyone can zoom out and have a good rest of the day.
Hey, Bill, did you want our clients to go to Fifth Third today?
Yes, if they could. I don't know if they can, but
He's got work things he's got to take care of today.
Okay, when can we just figure that out on the record, just so we don't have an issue?
25, so they can file joint tax returns.
What's the issue? I can talk to her when it's convenient for both of us.
We want to make sure it happens. The sooner the
Yeah.
better with the RMD.
What's wrong with picking a date? Let's just pick a date.
Wednesday.
Can you go Wednesday?
Sure.
Okay, perfect. Wednesday. Okay, very good. I want you doing it Wednesday. Thank you.
Thanks.